former Whitewater defendant counsel and author of Contempt, a memoir of the Clinton investigation. Ken Starr, his take on this. Ken, always good to have you. You know, I noticed in a couple of your comments post this report's release, you said, we went to the brink on obstruction, but didn't quite get to obstruction. What did you mean by that?
Right. Well, I mean by that there's some pretty unflattering acts, and no one should be applauding the acts. But here's the key. For the President of the United States to direct the firing of the special counsel, bad move. But, Neil, it didn't happen. The fact that it didn't happen shows that the President, at the end of the day, whatever he thought of the investigation, knew in his heart, I better not pull that trigger. Richard Nixon pulled the trigger. Ulysses S. Grant pulled the trigger.
But he did pull the trigger in this way, right, Ken? I mean, he did, if it weren't really for Don McGahn, for example, his counsel at the time, he could have pulled the trigger that the President wanted him to fire Bob Mueller, but he didn't. So it wasn't so much the President not pulling the trigger as some of the people around him opting not to pull it.
No, Neil, don't quibble on this. The President has the authority to do it. And so all he has to do is just to say, hey, Mr. McGahn, I hired you, please. I told you what to do. He didn't do that.
So he didn't force the issue, you're saying. And so because of that, that does not meet the definition of obstruction.
Well, first of all, I don't think that even if he had fired Bob Mueller, that had been carried through, that would constitute obstruction, right? So I'm just talking about the act that seems to have really galvanized everyone's attention and energy. Oh, he wanted to fire the special counsel. The President had the authority to do that. If he had been bribed to do that.
Did Bill Clinton have the authority to fire you?
Only with good cause under the statute.
Gotcha.
See, I was appointed, and everybody needs to come back to this, I was appointed under the statute by 3 judges, whereas Bob Mueller, of course, was appointed by the Attorney General. And he's an officer of the Justice Department. That's why he has to comply with all these department policies.
You know, John Dean, of course, you know, of Watergate fame, he quibbled with this no obstruction thing, Ken, saying if you endeavor to obstruct, and there is much evidence here of this endeavor, you violated the obstruction statute. Now, I'm not a lawyer. I know you're an extremely good one. So obviously people interpret this whole obstruction thing differently. Now, clearly, even the Mueller folks could not determine one way or the other on this issue. So shouldn't it be a dead issue, or is it a dead issue?
Well, it may not be a dead issue politically, but it should be a dead issue legally. And why is that? And that is because Bill Barr and Rod Rosenstein consulted widely within the Department of Justice. I had the privilege of serving 2 tours of duty there, and so I know what that process was like. Bill Barr's not just sitting around, what do I think? He's consulting with the experts. And with all due respect to Bob Mueller and his staff, they have a very capacious view, obviously, of the obstruction criminal statute. And they're wrong. I respect them, but they're just absolutely wrong under the Supreme Court's very, shall I say, appropriately narrow construction of what constitutes the crime of obstruction. So sometimes we talk about obstruction in a very general, common, everyday sense, but what we're really talking about here is, did the President of the United States commit crimes? And the point is, he did not, as I see it, including with all of the obstructive acts. I think Bill Barr's judgment, Rod Rosenstein's judgment, was exactly right.
What do you get then from the cooperation issue? A lot of people have been saying, oh, the President was fighting this tooth and nail, but then I read details of providing thousands of pages worth of documents and virtually providing everyone in and around him an opportunity to speak to Mueller, including Dan McGahn, who apparently had 30 hours of back and forth with the Mueller team. So it looked like he was, despite the times he would get furious just about a probe himself he found unfair, he wasn't blocking it in that sense. So is that a fair criticism?
It's a huge point that, in contrast to Bill Clinton, in contrast to Richard Nixon, in contrast to Barack Obama, the President not only did not invoke executive privilege, he affirmatively authorized Don McGahn to just be transparent. I'm surprised that the President allowed that, but he did. And that suggests to me, again, this overall intent. He hated the investigation. He thought it was terrible for the country, terrible for his presidency. And I happen to think that he's right. That is, we could have gone in a totally different direction, used a different mechanism. As you know, I've talked about, why didn't we use, if we wanted to determine whether it was collusion or not, use a 9/11 commission and have public testimony so we're not waiting for 2 years to see what Bob Mueller found through the use of the grand jury. There are advantages to that, but the big disadvantage is all this secrecy, all this buildup. But if the president is going to allow this openness, why didn't we see some of Don McGahn's testimony unfold just as the Senate during the Watergaters said, well, let's hear from John Dean. We all would have been better by that process. That's not to blame Bob Mueller. It's just we too frequently, Neil, say, let's have another special counsel. I say be very cautious, having experienced it in the iteration of an independent counsel. Be careful what you ask for.
Yeah, it's usually lawyers asking for it, Ken. No offense to your fine field. All right.
I know.
I'll leave it at that. Thank you very much, Ken, and coming in on a Saturday. I appreciate it.
Good.
Ken Starr.